So welcome everyone to the next session in our Berkeley BCLT career series. We have, again, another great program that Wilson Sonsini has been nice enough to volunteer a little more time to help us explain practice areas and how they vary among firms. As you've heard me say before, just because somebody says I've got a practice area doesn't mean it's going to give you the same day-to-day life from one firm to the next. And Wilson, we've talked about, with its high-tech practice and life sciences practice, presents a different kind of a firm and than many others. So what I want to do today is walk you through what a trade secret practice looks like, and then what a trade secret practice at a firm like Wilson would look like. And often, you hear trade secret right after the word patents. It's a patent and trade secret practice. And they are kind of lumped together because they can both be technology, but they don't have to be. And often patent litigators do a little bit of trade secrets, but what I found through the years is that trade secret lawyers that do a lot of trade secrets just consistently are better than people that dabble in it. And so what we have here, Wilson has true trade secret practitioners in this, and there's a counseling side to it, and there's a litigation side to it. Kind of an interesting practice that goes well beyond the classwork you may find at school. So with that, I'm going to introduce first Amy Candido. Amy's a partner in the San Francisco office. Amy and I have known each other for many years from the opposite sides of a litigation many years ago. And Ariel Anaba, she is from the Los Angeles office of counsel here at Wilson too. So you're also seeing how a practice like this works across multiple offices. So with that, and with that introduction, I'd love to just start with both of you and ask, what does it actually mean to be a trade secrets lawyer?
Well, I guess I'll jump in, Wayne. As you sort of hinted, it can mean a lot of different things. And I think it means somewhat different things even at Wilson. Wilson has trade secret lawyers that are sort of more part of our employment group. They're like people who sit in our employment department or group, whatever they call that, who the trade secrets work that they do comes more out of sort of, employee movement type cases, when people change jobs, that can give rise a lot of times to trade secret litigation or counseling. When you have to, there's a lot of trade secret work that happens behind the scenes, advising employers about how to protect their trade secrets, how to create policies and enforcement regimes at a company to make sure you're taking proper steps to protect your trade secrets, have good policies that do that, and that you're implementing your policies properly, sort of procedures around employees leaving companies and bringing in new employees, that you're taking the right steps to make sure that a new employee that you hire, let's say, isn't bringing the trade secrets of his or her other prior employer into your company and sort of tainting what's going on at your company. There's a lot of stuff involved around that tends to be very employment department related. And then there's people like sort of Ariel and I, that we are sort of much more litigators, trial lawyer types, that the trade secret work that we do really comes up more in connection with high profile trade secret and patent, those patent adjacent sort of lawyers that do a mix of trade secret and patent and other commercial litigation as well, but it comes up in that context. And we also have some people who are more purely trade secret litigation all the time, but are still kind of more in our sort of purely litigator trade secret space, and less, well, they still do counseling too, because I think it's inevitable as a trade secret lawyer that you're doing counseling. So I guess sort of like within Wilson, I think that's what it looks like. But broader picture, I think the universe of trade secret lawyers probably does kind of fall a little bit along those lines of people that kind of end up doing more employee movement aligned stuff and people that do more litigation and tech driven cases that tend to be the bigger one-offs versus people that are doing more relationship driven trade secret work with the same kind of clients over a longer period of time. That's my sense, at least.
I think for me, most, if not almost all of it is in the latter category. And it's normally stemming from some kind of contract. And somebody says you breached your contract in one way or another and took information as a result of access that was gained by virtue of the contract, right? So my first trade secret case stemmed out of a state court proceeding from a breach of contract related to an acquisition. The inventors / founders of this company that had been acquired said, you owe us money pursuant to these milestone agreements out of this contract. And so I was defending the company that had actually done the acquiring. And as we get into discovery, we find out that the founders had taken information that was supposed to have been transferred and use it to start their own company. So voila, you have a trade secret violation, right? By virtue of a second breach of contractual obligations. And, there's lots of different ways it can come out of collaboration agreements, it can come out of pitches, etc. And, I think the cases are fun because a lot of IP cases have a theft theme to them. You can see a lot of theft themes in patent cases. And by that, I mean, not only did you practice my patent, but you knew it was my patent and you took it anyway, right? In trade secrets, it's like flat out a theft theme. And so both on the defense and the offense side, it's more personal. It's more emotionally charged. The depositions tend to be more fun. It makes for more interesting litigation. Most of my cases stem on the life sciences side. I've done high-tech side cases as well, but that's my technical background. It's in bio and chem, and it is helpful to have a technical background if you're working and be able to understand the technology that's at issue, especially for a trade secret case. It's certainly helpful for a patent case as well, but for trade secret cases on the defense side, and even if you're on the plaintiff side, really understanding that readily ascertainable requirement. So I'm not sure, it seems like you guys have probably taken trade secrets, but just generally speaking, a trade secret isn't a secret if it's not secret. And something isn't secret if those who have general knowledge or experience in the field would know about it, right? And so in a trade secret case, having an understanding of like, well, what would someone with general knowledge in this field know? And there's similarities to how you kind of put together that kind of defense in terms of as compared to like a patent case. But it's not exactly the same. And so having that technical background definitely helps. It can help facilitate conversations with your client, can help you come up with ideas, and it can frankly help you recognize issues. Like in the case, my first case, when we were looking at the documents, I found the trade secret issue because I'm reading this technology. I'm like, wait a second, this is different, right? And because I understood what the technology was, I knew it was different than what, I was able to discern that like, this is something new. And how come I'm seeing this new thing in a patent application by another company? And no one else on the team recognized that because they didn't have the background to even understand really what they were reading. It just would have looked like a bunch of, DNA sequences or whatnot. So it's one way that your technical background can kind of be helpful.
Well, I think that's something that can't be overlooked. You mentioned, I love the word personal. You know, patent cases, a lot of technology cases, you spend sometimes years looking for a theme that a jury can connect to get away from the technology, or not get away from it, but technology doesn't keep people awake at 3:30 in the afternoon in a hot courtroom. A good trade secret theft story, that's fun. That looks like TV. I mean, it's not fun if you're the one that was stolen from, but it's a fun thing for the jury. There's a villain, there's a hero. You know, it's the stories that you like to tell and that litigators like to tell. So that's a great way to put it. It is more personal, and that makes it more energizing as a lawyer to be involved in it, and maybe sometimes more challenging to handle the clients, because anger is not a great emotion that goes along with litigation. So, but I love that description of it's a little more personal. So, well, let's talk about how you got to a trade secrets practice. You know, that's not often when you as a young student or a student coming out of school, people don't really say, do you want to be a trade secrets lawyer? You want to do litigation, you want to do tech litigation, you want to do corporate work, you want to do transactions. Trade secret doesn't pop up there. How do you get from law school to kind of the senior levels that you're at on the trade secret world?
I can start since I did it more recently.
Good.
I knew I wanted to do IP litigation, and I knew I wanted to have a practice that involved science. I'm still not entirely committed to not being a doctor. I might change my mind.
Over my dead body.
So it was important for me to be able to do cases where I'd get to learn new stuff. And the thing about patent cases is most of the time patent cases are actually about old stuff. It's about technology from like 10 years ago for the most part. Trade secrets are typically about new stuff. And the reason why is most, especially in the life sciences field, most companies patent their technologies. And so you have brief periods where things are arguably secret, and then they start publishing a bunch of stuff about it because you have to get FDA approval and file all of these regulatory things. And so it does tend to be about cutting edge technology, which I find exciting. And so that's kind of what drew me to that, was like, oh, this is actually technology on something new. Every once in a while you can get a patent case on something new, but for the most part, you get patent cases about old stuff, because you want to get the damages up. So that's what kind of attracted me to it. I think I kind of got lucky in the sense that my first firm had a trade secret practice, and so I had those opportunities there. As I think was mentioned before, there do tend to be trade secret issues that can be embedded in other types of cases, right? So if you have contractual disputes between companies, you can find some trade secret issues, especially if there's exchange of information, like in collaboration agreements or pitches or acquisitions, that sort of thing, like looking at what information, did the information stay where it was supposed to be? Because information doesn't always say where it's theoretically supposed to be. So you can kind of look for those issues there. And I think there's opportunities, if you find yourself, you're working on a patent case, like looking for a lot of times associates are the ones that can find those documents to find those claims. You may not know it from the outset. Which is how like my first trade secret cases came. Like they weren't pitched as trade secret cases. They were contract, a state court contract dispute, but it turned into a trade secret case because of the documents that I helped find. So yeah, that's my path.
Well, I mean, I was lucky because back in the dark ages when I went to law school, we didn't have to make this sort of hard decision that sounds like sort of today's law students are having to make these more narrow decisions earlier on. And I just sort of had to decide between litigation and corporate. And it was very obvious to me that I wanted to litigate because I loved to write, and I loved like digging into cases and reading cases and using cases to, you know, put together arguments and dealing with, you know, facts and sort of the human story element of litigation. That's what I loved about law school, and that's what attracted me to litigation. So at first it was just sort of that easy choice that litigation was clearly what I wanted to do. And I started off at Cravath, where you got to rotate sort of from partner to partner. And by virtue of sort of doing that, you got exposed to different types of cases. And I did that for a while, doing, you know, securities, antitrust, auditor, negligence, like more businessy sort of stuff. And at one point I rotated to a partner that was doing patent litigation and got exposed to patent litigation, which I actually, you know, really enjoyed. I thought it was fascinating to get to sort of interact with these incredibly smart people. At that point in time, I was at IBM, who were doing these really cool technologies. I was getting to go to IBM, you know, semiconductor fabs. And you were suddenly dealing with witnesses who were excited to talk to you, to like tell you about the technologies they were working on, instead of investment bankers that were like, you know, time is money and you're keeping me from, you know, the trading floor, and like, you suck, I'm dealing with lawyers and I hate you. To people who were like happy to see you, kind of, it was such a different dynamic. And I remember like one witness who was like this woman who'd been a code breaker in World War II, and she was like this IBM fellow, like super cool people. And I felt like every case, like the interesting challenge, like the lawyers got to do the most important fun part. So like in claim construction and patent case, the creativity in the case that was going to make the difference, it felt to me was like what the lawyers were doing. Whereas I sort of started to feel like the most creative aspects of some of the other cases were what like the expert witnesses got to do, and less what the lawyers got to do. I'm sure everybody would beg to differ, but like it felt that way to me at the time. And so I loved the patent cases. And you kind of got to go to court more because at least there was a claim construction hearing. That was a meaty kind of in-court thing that definitely happened. And so I kind of got attracted to patent cases. And then when I switched firms, I ended up at Quinn Emanuel, and we did years, a good decade of patent trials, and kind of got to become a patent lawyer, doing patent trials. And then there was this like switch that is more of an sort of for all sorts of reasons about patent law, where patents became slightly less of a thing. They're still clearly a very big thing, and trade secrets sort of started to rise and fill this the space about protecting you know, intellectual property with trade secrets instead of patents. And I got the call that, hey, oh, there's a trade secret trial where we need another set of hands. Could you help us? And it was in this very weird situation where a judge in San Francisco dabbered it out, essentially said that our damages experts, he excluded all of them. So we were going to trial as the plaintiff with no damages experts. And they needed somebody to help figure out how are we going to put on a damages case with no damages experts. And so that was sort of, I was tasked with figuring that out. And it was a very strange case too, because it was a small company that this was it for them. They had like, someone stole their trade secrets, and their entire value was figuring out, you know, how can we extract value from these trade secrets? So it was a really interesting and difficult challenge to both figure out how you put on a case without experts, but also trade secret damages is this like much less defined. I mean, if you're doing patent damages, there's like a zillion cases from the Federal Circuit that say, like, this is how you do patent damages. You can say this, you can't say that, you know, and everything rises and falls with what the Federal Circuit says. In the universe of trade secret damages, there's two statutory provisions and then a giant pile of case law. Goes just like every which way to Sunday. Things are still 100% evolving. And it's so much, there's just this, again, this huge area of creativity for smart lawyers to really apply themselves and figure out, like, how do you make law? How do you help steer the law? Especially when, historically trade secrets were used in a very different way than they are now, where there's these case companies where, you take this Waymo Uber situation where trade secrets are being applied to protect incredibly valuable assets where people had spent, hundreds of millions of dollars with respect to your developing technology for which no one had sold $1 worth of anything yet, right? This nascent sort of technology idea. How do you value, traditionally, right, we value markets with sales. And that's what the sort of body of case law had been around. But now we're trying to figure out how do you apply that to a market with nothing in the market yet. And it's just fascinating sort of space to figure out how are we going to push the law to figure out how to deal with this new kind of problem. And by virtue of working on that first case, I got like deep into the world of trade secret damages. And then that just kind of started to snowball for me into this fascination with trade secret law and all the different ways that there were still all these questions unanswered and the law was evolving. And of course, it's so much fun because of the stories and the people and the facts. And yeah, I just got hooked and kind of kept on going. So that was, sorry, a very long-winded answer, but that is how it happened. But I think there's something to that, honestly, for law students to realize that, like, what might feel like a really big decision you have to make today, it changes. Whatever you think you're going to decide today may not be what you're going to be doing in 5 years or 10 years. Things evolve. Nothing is, the final call, and your career is going to take a path that you will not be able to predict. And part of it is make the best choice you can, and then see where it takes you.
Well, and that's a good point. Lawyers that have been around for more than 10 years have seen shifts in their practice because new areas of law emerge and old areas of law become commoditized or just disappear.
Yeah.
So it's an evolving practice even for senior lawyers.
Absolutely.
So what you're talking about is getting a foundation up front, kind of a skill set, lets you make those pivots through it's not really pivots, it's evolution.
Yeah. There are people who make 100% pivots too, and that's okay. Like, there are people who make choices and then go, oh my God, like, this is not at all what I thought it was going to be. Like, I hate this and I need to make a switch. And that, that happens too. And I think firms are generally, okay with that. Obviously, if you're a hard worker and smart and are willing to, apply yourself, firms are pretty flexible about accommodating, people realizing they're not in the right spot.
Though, Ariel, I can't imagine any accommodation if you go to med school.
No,
I don't know how that would work. That may be a pivot too far.
Yeah.
Maybe we'll see.
If you make it work, come back. I'd love to know.
What she does on her nights and weekends as her own business.
That's exactly what everybody wants in their doctors. Somebody that got from the night program.
Doctors.
Well, so obviously the two of you work together a lot, but you're not from the same office. Tell me how that works, because there's, I hear students struggling with the virtual world now. If people aren't in offices, if people are in different offices, where are their mentors going to be? Who are they going to learn from? How are they going to move from first year attorney to your level? So what's made things work for the two of you?
Yeah.
Why don't you take that?
Yeah. So so before coming to Wilson, I was a partner at a boutique that was almost entirely remote. Like, there were offices, we had offices, but I lived in Ventura and my office was in Palo Alto. So
The long commute.
Yes, very long commute. So and I was homeschooled after second grade. So the whole in-person learning thing has not ever really been a big deal to me, but I understand that it is a big deal to some people. I would say, generally speaking, you know, Amy and I, at least from my perspective, are very close. I've never actually met Amy in person,
Yeah,
but
know.
I consider her a friend,
Yeah.
you know. And part of that is it's just communication, right? And as a junior associate, I remember there were a lot of times when I had no idea how to do something. And since I started off at a firm where, you know, you were expected to show up, most people showed up 5 days a week. At least so far as I knew, most people showed up. I showed up 5 days a week. Most of my friends showed up 5 days a week. I'm going to assume that most people did. There were times when I would go in somebody's office and bug them, but I will say I normally preface that with like an email to see if I could, or a phone call to see if I could. And you can do the same thing with like Teams or emails now. Like across my cases, I have junior associates literally all over the country. Some of whom I've met in person, some of whom I haven't. And they'll message me or call or whatnot to ask questions, to get feedback, etc. I mean, I think it requires intentionality. If you're working across different offices, you've got to be willing to put in maybe a little bit of extra work, because you're not going to have like a lunch, or you're not going to have like coffee. You can't just say, hey, I'm going to go grab X, Y, or Z and like build those kinds of relationships that way. But that isn't to say that you can't build relationships across offices. I know that you can, because I have, not just with the partners that I work with, but also with like the associates on my teams. It just requires a little bit more work and a little bit more willingness to kind of be flexible. You know, I've had virtual coffee dates for some of the associates for the associates that I mentor, I try to get them to put an hour on my calendar every month just to check in. And, you know, I'll ask very specific questions like, you know, how are you doing? You know, tell me about this case. What are your hours? Like just questions to kind of see how they're going. And that requires intentionality on my part, but it requires intentionality on their part too. To like make those meetings, and also to be a little bit more direct than perhaps you would be if you were building a relationship a little bit more slowly over time. Like small chat is not the best way to build deep relationships virtually. I don't think it's the best way to build deep relationships just generally. But certainly, like, you know, if you want to have mentors, I think, and you're working with partners across different offices, you know, be direct. If you have concerns, ask for feedback. Don't be afraid to hear somebody tell you that you did something wrong. Look at it as an opportunity to learn. And I think it's fine. But, you know, are there pluses to working in the same office with people being in the office? Maybe. But ambushing, you know, I do work and I do go to the LA office, you know, 3 times a week. Frankly, most of the time, if somebody ambushes me in the middle of my day without it kind of being planned, I'm not probably going to have that much time to go through it in person in the office. Like I still need you to put that on my calendar.